Dear guests, dear colleagues, I'm very glad that I can open the second panel that is focused on civil law and environmental protection. It's a really challenging panel because, as you will see, that the civil law and the environmental liability is a little bit far from each other. So it's really one block that is facing the challenging issues. And for me, it's also the challenging panel because I'm regularly focused on the criminal law, and now I need to introduce the civil law panel. So it was very inspiring for me to read all of the articles, and I have really found very interesting and few and new information in the articles. I have to say that it was similar, the same but different in each article. So there were a couple of similarities and resemblances in these all legal orders, and that's why I chose to make it in one row and to somehow describe the crucial points of the civil liability in all of these countries. Firstly, I want to introduce our panelist for the Slovak Republic. Is here the colleague Dr. Marek Ivančo from Comenius University. From Hungary should be here Dr. Zsofia Hornyák from University of Miskolc. And from Poland is here Dr. Zrałek from University of Silesia. And from Czech Republic is here Dr. Bártů from Masaryk University in Brno. Thank you, all of you, for coming. And now I will come to my, I hope, short presentation. And afterwards, I will give you the word for answering my curious questions to your articles, because I suppose that it could be interesting to find some resemblances and similarities in the legal orders. What I have found in your articles and presentation is that the general compensation mechanism in all of our countries is based usually on civil law, civil codes, because actually there is the general liability model for all damage consequences. It means that the environment is usually only one of damage consequences that could occur, and you can actually ask for the damage claim in the scope of this general civil litigation. However, there are mentioned also some special laws in each of the country, because in each of environmental law that is focused, specialized on environmental protection, there are some structures and models how to face also the damages in the environment. So you can see that also Poland, Czech Republic, Hungary, and Slovakia have their environmental acts, Environmental Protection Act, or, for example, Nature Conservation Act, or Act on the Prevention of Ecological Damage. It means that these are mainly administrative laws, but they incorporate some civil law structures how to cope with the damage when it is made in the field of environmental protection. So, when I searched in these articles of our colleagues, I have found that there are 5 different types of civil litigation that you can use for the damage claim. Actually, usually we start from the so-called general provisions that are facing the so-called fault-based damage claim. It means that usually it is based on the form of negligence or intent, and the plaintiff must prove the damage. Then there is the strict liability for some hazardous operations or transport means, where it is opposite version. It means that the burden of proof actually lays on the defendant, and then you have some special types of responsibility. For example, you can ask for protection of personal rights, also in the scope of environment, or you can ask for so-called neighbors' rights. It means based on the property. And there is also some kind of contractual liability that is based on some contractual relations between parties. Actually, these four are usually out of contract liabilities. So I will try to make it quicker, but the fault-based damage claim is usually based on some general provisions, like it is in Slovakia, that everyone is obliged to act so as to prevent harm to health, property, nature, and the environment. So it is like the general clause, how you can behave, and if you don't do it, it is the violation of this general legal obligation. What is the problem? That you must prove that you have suffered the individual damage as the entity. So it is not like the common good that I can ask that, sorry, about my house there is the polluted air. Usually you can prove that you have contaminated soil at your garden and so on. So you must prove individual damage. You must prove the causal link, that there is the connection between the perpetrator and damage. And there must be so-called violation of law. Only in case of so-called wrongfulness of act you can ask for damage claim. It could be based on negligence or intent, and the burden of proof is on plaintiff. In cases you can ask for exemption when you prove that you have done everything necessary care, or it's the force majeure. So there are some exceptions when you are not liable for the damages. Anyway, what you can ask? Usually you ask for compensation, but you need to focus on that it is not the kind of public law. It's not the punitive function. It means that you can ask only what you suffered, not more. You can ask not for some sanctions to the defendant, and also it is very difficult to claim in personal scope, in private scope, that please stop polluting the air, because these claims are usually not of that kind. Sometimes you can ask also immaterial damage when it is the gross negligence or intent, and the kinds what you have suffered could be loss of property that it incurred you higher costs, or you can have the damage also on persons. There could be different types of damage that you can suffer, but usually the people ask for material damage, what is actual damage, and loss of profit. For example, actual damage could be like acid rain caused the devaluation of forest, and you will ask for compensation for this damage. Or loss of profit, like our colleagues mentioned in their article, that if there is the huge death of bees, you will have not the honey, and you can not sell the honey, and you will simply have lower profit. Also, what is interesting, that usually there is no maximum limit for the damages, and for example, I have found in one article that sometimes it is very difficult to find a monetary explanation what I have suffered. So usually it is based on the property value. and that the whole property, when I fell the trees illegally, that will be not the cost of trees, but the value of the land without the trees and with trees. For example, what was interesting, I have found that in Czech Republic, there is, for example, in Atomic Energy Act, that the license holder only is responsible only to a certain level. So there is like exception that there is no limit for the damage compensation. What is crucial, that the environmental damage is not traditional, has no traditional monetary value. It's very difficult how to evaluate the environmental damage, and the environmental damage is usually defined not in civil codes, but in some administrative laws. So what you can also ask is that you can ask for restitution to the original state, and there is the preference that you firstly ask for restitution, and only afterwards you ask for monetary compensation. So it is the, I think, crucial idea of all our legal orders, that in case of environmental damage, there should be firstly restitution, and only if it is not possible, if it is not feasible, if it is prohibited by law, or if it would be too expensive, then it is possible to get the money compensation. It is not also impossible that you receive partly restoration and partly the money compensation. And as I mentioned, it could be not more. You cannot give the court cannot say that, okay, we will give him more damage claim, we will give him more penalty, that he will not cause further damage. In private lawsuit, it is not possible. I can introduce who is the responsible subject for such claims. As was mentioned in the articles, usually it is not the state that asks for the compensation. Usually are there private entities that ask for the damage claims from the private other persons on and against the state, because the state claims are usually administered by the public law, by the criminal law and administrative law. So it is not usual, typical that the state will sue a company at the private court and the private lawsuit. And what is special, I have searched for, and that will be also a question on one of you, that usually also the society could ask for some damage compensation or group of people, but in Czech Republic it's doubtful, and I will maybe listen more from our Czech colleague, because they said that, okay, it is the civil law is based on individual rights and not the society as a whole. So they doubt if could be also the society be the plaintiff in such cases. And also what is special are these private claims against the state, because it's typical for the environmental protection that actually the state is responsible for the environmental protection, and if the state does not do the job good, you can ask for compensation from the state for such consequences. But again, it is only on individual rights, not the common good like pollution of the air. Also against the state, you can ask only for a damage claim that you suffered as the person. But what is complicated, that you need the decision that this was wrong. Okay, there was some special case for Poland, but I think I see the time. I need to speak more quickly. But what was, for example, very special that in Poland was mentioned that you can ask the state that the state will buy your damaged lands, and they will compensate you that they will buy actually the damage. Okay, the strict liability, everybody I think knows what is it about. It is for the special dangerous operations like electricity plant and atomic energy plant and so on. So the operator already works with some danger, and that's why you only need to prove the causal link between the activity and the damage, and there is no unlawfulness. They could not break anything, only the operation of this activity is the ground for the damage claim. So the burden of proof is on defendant, and he can exculpate mainly in all legal orders on the force major grounds. The special thing is about the personal rights. I will not go across all of the condition, but personal rights is like the claim when there is the polluted air, I suffered my health problems, I have the problems with my breathing and lungs and so on. So actually also in this scope of personal rights is the claimant's burden that he must prove that I have suffered something because I live near the atomic energy plant and I have suffered cancer. So you need to claim and prove that it is from this ground. But it's again a little bit complicated when you are thinking about the environmental rights, because there is no individual material loss. I took sentences from the articles that the violation of the right to live in a clean and unpolluted environment, which is not in itself a personal right, may harm a personal right such as health, and then receives the protection provided for personal rights. So it's only like the intermediation between the environmental damage and your personal damage. Then you can have the so-called neighbors' right claims. It's based on the properties that are close to each other, and and there is also not mandatory unlawfulness. And the last is the contractual liability. Actual, I see that there is time running, so I will not go through all these special environmental models for each of the country because I think that maybe our guests will say more about it. But I have also directed these questions this way. So there exists the special model for damage claims in environment, also in Poland. Also in Czech Republic, it's based on this special laws, and you can see that, for example, under ecological act, the claimant could be only the state, or for example, in Hungary, it's very special that there is the model of prosecutor that could ask for a ban of some illegal activities in the scope of environment, or the so-called Ombudsman Commissioner for Fundamental Rights could inspect such a larger violation of rights also in the scope of environmental protection, or some social organizations could start the civil lawsuit and could search for the evidence against the perpetrators and could resend the information to public. And what is, for example, special for Slovakia, that we have a so-called Representative Actions Act. I have asked the colleague to somehow more explain how it works, but it's the so-called public interest action where you need to find at least 20 injured people, so-called consumers, and then you can ask for protection like a group because you suffered the collective rights. And usually, before you fill the case, you need to notice the intent, and only some registered entities could be the representative of these injured persons, and so on. Okay. What is the shortcoming of all these responsibilities? That environmental damage is not the private law tool. It's not the private law term, and it is very difficult to define what is actually the environmental damage for the civil law purposes. And it is very subjective category. You can evaluate the environmental damage only on economic criteria. And the environmental laws do not have financial consequences. And there were some challenges what proposed our colleagues, that you should have insurance for environmental liability, that you can give the legal personality for some national parks, rivers. That was the proposal from Poland, or from Czech Republic, that you should distribute otherwise the burden of proof, have compulsory insurance, or more mediation for such cases. And what was interesting were the conclusions of our colleagues. In Polish article, I found that classic private law claims with the traditional judicial approach are not very efficient in the environmental damage cases. So Polish guys are saying no civil law for environmental cases. The same in Czech Republic. Private law significantly limits the possibilities for compensating for damage caused to the environment, difficult for the injured party to bear the burden of proof regarding all prerequisites for the obligation to compensate for damage and to prove causal link of the extent of the damage. But our colleagues from Slovakia have said that it seems clear that the most environmental offenders, the vast majority in fact, are not prosecuted. So civil or administrative fines are a much more potent economic deterrent which can complement more traditional criminal sentences. In Hungarian conclusions, I didn't have found clear decision if you want to go to left or to right, but you can see that the final verdict on the responsibility is not the same, even when we have very similar legal orders. And now we can come to questions. I will ask our colleague from Poland that will somehow answer the questions that you can see here that I have sent to our colleagues. Thank you for your work.
Thank you very much for having me here, and thank you for a great introduction. Not thank you for difficult questions, but somehow we need to cope with it. So
I was really wondering how you can then prove in civil law case the damage, if you have so much tools how to claim the damage, and then what is more efficient, because you have introduced double model.
Okay, so actually, in most cases, you cannot prove. So that's the answer to the first question. That's the problem of this kind of tension you have mentioned, that despite the model, if this is strict liability or fault liability or any other base, you need to kind of prove the link between the environmental damage to individual situation of a person. And that's kind of a very challenging thing. Still, when we say about the evidence handling, it's kind of, there is no any special regulation for environmental cases, so you can use all tools from civil law evidence handling. Maybe in case of environmental cases, the regulation of the access to public information might be kind of crucial one, because you can always ask for public information and use it in your civil claim. And when I address the second problem, the efficiency of the action, that's, I would say, sad, and that we can see a tension, because from one side, the civil law is the major tool to develop the civil society. So when the individuals do not have any other ways to challenge the environmental damage, they have to go for civil law claims. But on the other hand, the civil law claims are not working for them because they cannot translate into the individual situation. That might be justified to some perspective, because when we were talking about this monetary compensation, for example, in civil law, there is this compensatory function. So the money goes to the plaintiff, not to the environment. So that's kind of misleading, because even if you are challenging the state or the other private person for the sake of protection of the environment, you can ask only for protection of yourself, not the environment. So that's the tension, and that's why the rules, that all this problems come to the conclusion that the rules from environmental law in Poland that are supposed to work in civil law cases are, I would say, mostly dead, that people are looking for other solutions in civil code rather than in environmental law. And particularly, they are looking for this private rights protection. So that's there were many cases that individuals were looking for the private rights protections, trying to connect, so telling that the environment is our private right, but that didn't work. So the final judgment from Polish Supreme Court from 2021, Supreme Court was changing its approach to this problem, but the recent approach is that this right to clean air and to environment is kind of a common good that does not translate directly into the private good. So that's what you have printed, the sentence from the Supreme Court decision, that this common good has to be translated into private good as health or some other individual values. So thank you very much. I believe there is no bell ringing, but I don't know if it bells for
supply your answer. So this structure that is in this environmental protection law is actually very nice formulated. It seems like very efficient and functioning. Do you say that it is not so working and it is not so used by the private entities?
It's not. Let me just shortly read the translation of this major regulation, that everyone who is directly threatened or harmed by an unlawful impact on the environment may demand from the entity responsible for the threat or violation to restore the lawful state of affairs and take preventive measures. So there are no those monetary compensation in environmental law, but still, this everyone, you need to make this path again from the person that is challenging or damaging the environment to threatening or harmed unlawful impact on environment, but that's not the actio popularis. So you still have to transfer it somehow for your civil position. Because if we believe that the environment is not a common good but private good, we generally open the area of actio popularis, which is something that civil lawyers are afraid of, that you will have thousands of cases. If so, that's still. There is this environmental law can work for NGOs because they do not have to prove this direct link in their cases, but still it is the very limited impact. I would say that this regulation was modeled more for the state to challenge somebody who is doing environmental harm. But as you mentioned, the state usually takes criminal or administrative paths, so not the civil ones. So civil ones are for NGOs and for private persons. So thank you very much.
So at first I would like to thank for the opportunity to deliver my speech, and I'm really glad to be here. And the first question is related to relationship between environmental damage and the damage in the sense of civil law. And I would like to point out that there are two categories that only partly overlap. So there are a few situations that may occur. So we can have only environmental damage. We can have only damage in the sense of civil law, and we can have a damage which is both at the same time. And only in this situation we can use private law provisions and private law instruments to protect environment or to compensate for environmental damage. And okay, and it is generally the plaintiff's duty to prove a breach of duty. This duty may stem from environmental law, but does not have to. And or he has to prove that there was a materialization of a dangerous or of a risk of some, I don't know, operation, for example, particularly hazardous operation under section 2925 of our civil code. So it is generally not enough that he proves that environmental surroundings were deteriorated, but there is new way. There is one fresh decision of our constitutional court, which says that there is maybe a way through personal rights, because we have a personal right to live in a nice environment. So maybe it's a way. I have to say that I didn't consider it because it's not it's quite new, so it's not in the article. Maybe I will add it there. So the plaintiff has to prove much more than this deterioration. He has to prove breach of duty. He has to prove materialization of risk. He has to prove that he has suffered a damage, causal link, and so on. And to your second question. Or maybe
the question is because you have mentioned something like that the society cannot be the active.
Generally not.
So how you face such cases that are like huge number of people is affected? How you do face it?
Well, in civil law, there is a rule that only the person who has suffered the damage can claim the damage. It's a general rule. There are some exceptions. They are very rare and they are not worth mentioning here. It's not important. So I can claim only the damage that I suffered. So if there are 100 people who suffered the harm, it's their choice to claim for this damage individually. So
you need cases for such.
Now we have special civil proceedings which may make it easier and to just one proceeding, but it's I don't know 3 or 4 years old, and I haven't seen such a case. But there is a possibility for example, natural person who suffered an environmental damage, or for legal entity under private law which is engaged in environmental protection, then can initiate administrative proceedings by public authorities, and these proceedings may lead to compensation of this damage. But it's administrative law; it's not civil law case.
And maybe supplement question that was also addressed to our Polish colleague. Is there some special procedural provisions how to claim the environmental damage, and which tools do you have for these cases, or no?
We have no special provisions in civil law. We have no special provisions. Of course, there are some provisions in administrative law or so on, but not in civil law, not in civil code and so on.
The civil code and civil procedure code tools for collecting the evidence.
Yes.
If you don't, if you are not successful in reaching the burden of proof, you simply.
Yes, but there are some special provisions that are generally very strict to the, for example, operator of particularly hazardous operation. So the burden of proof is really low. You just have to prove that there is a danger. This danger has affected the damage, has materialized, and you have suffered the damage. So it's quite easy, but it applies only for these particularly hazardous operations. So it's not very hard, but it's easier, but only in these cases. And maybe I'm not sure if I answered all of the questions. I hope so. If there's...
There were, yeah, I think that because of lack of time, maybe I think that
if there would be any questions later, I'm happy to answer them later.
The audience. Thank you very much.
Thank you very much for the opportunity. And now I become two very complex questions, and I try to answer a little bit together. But first of all, I would like to speak about that in Hungary we have three types of non-contractual liability for damages. One of them is the general liability, which means, for example, the general rules of compensation. And the second one, if we already saw it, that the objectified liability, which means the liability for the hazardous operations. And the third one is the absolute liability, which means the liability for nuclear damages. And I didn't write anything in my publication about this topic, but at this point, I would like to highlight this kind of liability because of the questions. And when we speak about the objectified liability, which means the liability for highly dangerous activities, it means the liability for hazardous operations, the starting point is the rules of the civil code. And you saw it on the first presentation that Hungary has some special rules for the civil liability in the Environmental Protection Act and the Nature Conservation Act as well. But the basic of the rules of the liability is the civil code. It means that the rules of the liability for hazardous operations according to the civil code is applicable for the damages and the different is in the activities which cause the damages. What does it mean? It means that the civil code have some rules about the hazardous operation, the liability for the hazardous operation, and we have a special provision in this regulation. It means that the liability for hazardous operations is, so we have to apply it to the damage who a person caused to another person through activities that endanger the human environment. So not only the nature of the hazardous operation is decisive in this case, but also it can be only enough to endanger the environment, and that's why we have to use the rules for liability for the hazardous operations. But when I speak about the Environmental Protection Act, I would like to highlight that the Environmental Protection Act also says that someone endangered the environment is liable according to the civil code rules. And we have to apply the rules of the liability for hazardous operations. But the activity, it's much more wider when we speak about the civil code rules. It means that not only the endangering the environment can cause the damage if we have to apply the rules for the liability of hazardous operations. This wider circle means that not the endangering the environment, but also the utilization of the environment or the loading of the environment can. So in this case, we have also use the rules of the liability for hazardous operations according to the civil law. And it's very interesting because, for example, the utilization of the environment is not such a negative activity as the endangering the environment. So the Environmental Protection Act defines that the utilization of the environment means only the use of the environment. So make some changes in the environment, but it does not mean any negative consequence. And when we speak about the Nature Conservation Act, also we have to apply the rules of the liability of the hazardous operation according to the civil code. But the activity which can cause the damage is another when we speak about the Civil Code or the Environmental Protection Act or the Nature Conservation Act. And the Nature Conservation Act says that anyone who caused damage in violation of the laws and specific official regulations on the protection of nature is obliged to compensate for this damage in accordance with the rules of the Civil Code for liability for hazardous operations. And when we speak about the point of view of the burden of proof, so it's very interesting that the plaintiff can choose that when he make his claims, he refers the general rules of the compensation or the rules of the liability for hazardous operations. And it's much more favorable for the plaintiff if he choose the rules of the liability for hazardous operation, because in this way, the injured party has to prove only the damage and the causal link, and the person who caused the damage must prove that the damage was caused by an unavoidable cause that is outside of the scope of the highly dangerous activities. And you have the question that what are the mode of the compensations? Of course, we can do it in cash or in kind, but when we speak about the environmental protection and nature conservation, the primary aspect is to the restoration in kind. And for the second question, at this point, I already speak about the objectified liability, which is also a strict liability, but the other form is the absolute liability. And just a few words about it, I would like to speak about the nuclear installations. And in the case of nuclear damage, we speak about in Hungary the absolute liability. And we have a special act. It is the Nuclear Energy Act. And this act speak about a little bit about the civil law rules. And also it says that the compensation for non-pecuniary injury and pecuniary damage are regulated in the civil code. And we have some possibilities of the exemption and the limitations of the liability, which are the Wismaier case and also the contribution of the injured party. And the act of the nuclear about the nuclear energy also says that it has a maximum amount of this compensation. We already saw it in another country in your presentation. And in this case, we have two obligors. One of them is the licensee, and the other, the licensee of the nuclear installation, and the other is the Hungarian case. And at this point, I am ready with my presentation.
Ladies and gentlemen, thank you for the floor. Thank you for having me here. And let me extend the gratitude from Director of Comenius University, Marek Szczewczek, who co-authored the paper with me and unfortunately wasn't able to make it here. As regards my first question, it relates to the draft of Civil Code. Since it is just a draft, it is planned to be adopted in the next year if everything goes as planned. And it should be effective from the year afterwards, meaning it should be effective from the July 1st, 2027, if everything goes according to the plan. The draft should be a result of recodification process. The recodification process is a question which is kind of a hot issue, hot topic in Slovak Republic for over 30 years, 3 decades, since practically shortly after the Velvet Revolution. As of now, we do have Civil Code, which has been adopted in 1964, which is obviously not a problem per se. It's not a problem that we have something that has been in effect for 6 decades. Not at all, since we all know that the French Civil Code has been adopted in early 19th century, and it doesn't pose a problem at all. It has just solidified its position, unlike the Civil Code, which we have adopted in 1964. But it needs to be recodified and adopted because it actually holds to different case law. It actually contains the legal rules that have been obsolete, and that's actually the role of the draft. And in which way the draft actually is better or improves the position of the current Civil Code? In several ways. At first, it prioritizes the restoration as such. So it's not about money first principle. It's about restoration first, if that's possible, of course. So the first change, which seems quite crucial one, and which is in line with the current European trends, holds on to the fact that we would like to make restoration priority. The second aspect is that the debt itself shall constitute a part of the damage proceedings. As of now, it's not like that, which means if we are sanctioned by some environmental authority and we are supposed to pay fine, but we are not the polluters, it is the third person. That third person might have a debt, right? We are a creditor towards that person. As of now, the situation doesn't allow us to pursue the lawsuit against such person because the debt itself doesn't constitute the damage as such. With the new draft yet to be adopted, this should be remedied. The debt shall constitute damage, and that should make the enforcement of the damage incurred within environmental proceedings much easier. The next aspect relates to remedial costs. We
there are cases where, for example, the actual damage might be too undervalued, like well, okay? We do have a well somewhere in the forest that might have been damaged. The actual loss might be less than 500 euros, but remedial costs, meaning restoration costs, might exceed far more like that, like several thousand euros. According to the new draft, remedial costs will be part of the damage proceedings itself. So the damage incurred within, for example, wells, as something that I mentioned as an example, those cases won't be underrepresented because the actual damage that will be available to us will be far higher than that. And it will include remedial costs. Then there are the next problem within environmental cases are the cases where actually the actual damage is too burdensome to calculate, and it includes surveys which are far too expensive. According to the new draft code, it will be the judge that might explicitly address the topic. We will not need any expert service, which might cost, in some cases, far over tens of thousands euros. And the pollution of the land can be explicitly made easier with the judge discretion, right? No need for expert service in burdensome cases. That's as to the first question. As regards the second question, my answer will be far simpler and expedited, given the time that has already elapsed. As regards the second question, we do have Collective Redress Act, right? It has been adopted 2 years ago. The problem is it is based on consumer law. So the consumer law is gateway, whereas environmental law is subsidiary. But it kind of overlaps, meaning, it means that where consumer rights have been breached and they overlap with environmental rights, they might be protected within collective redress, which we actually do have. But it has got pros and cons. One of the disadvantages is that we need collective redress authority, usually consumer organization. Consumers, they cannot sue the state themselves, for example, the climate. We need to have our collective authority that will represent us. We can't do that ourselves. So that is one disadvantage. The other disadvantage might relate to opt-in principle, meaning only the persons that signed in with notary will proceed with the collective redress proceedings. Unlike, for example, the states, which are based on opt-out principle, and everybody gets included, unless they opt out, right? So the biggest disadvantage, to conclude, and this is the final sentence, and thank you for your attention, but this final sentence, its biggest disadvantage is that it is prioritized upon consumer protection, not environmental protection. Thank you very much.